Hi guys. So I wanted to kind of catch up with some of the side cases that I've been following. I did an update for Popcorn Planet. Um, Now I'm going to look at the New York Times case against Wayfarer. It's been a bit crazy, hasn't it, with all the unsealing. So there have been delays in getting to some of the updates. But in the New York Times case against Wayfarer, which you remember is for their reasonable attorney's fees and costs. The first update is that New York Times have made a request for judicial intervention because the case currently does not have a judge assigned. So they have now made that request and it's pending. But the big update is that the New York Times have actually filed for motion for summary judgment against Wayfarer. So I was going to go through this and I think at the end, I'm going to just kind of talk about how strong I think it is. I think that's the way I'm going to do it. So let's read through this because it's not long actually. It's only about 10 pages, the actual memorandum itself, the arguments. So, okay. Plaintiff, the New York Times Company, respectfully submits this memorandum in law in support of its motion for summary judgment pursuant to Civil Practice Law and Rules 3212. So, preliminary statement. A strategic lawsuit against public participation, also known as a SLAPP suit, typically sounding in defamation, is brought to intimidate or silence a person who has spoken out about a matter of public interest. That is precisely what defendant Wayfarer Studios tried to do here. After the Times published an article describing misconduct allegations against Wayfarer executives based on an official complaint to an anti-discrimination agency, Wayfarer, along with affiliated entities and individuals, sued the Times for defamation in federal court. Its claims were meritless and they were promptly dismissed with prejudice. But in the process, the Times incurred a six-figure legal bill. Okay. New York law offers a remedy. To discourage SLAPP suits, which chill the free exchange of ideas, New York's anti-SLAPP statute requires that court award attorney's fees to a party if it can show 1. That it was sued for speaking on a matter of public interest, and 2. That the suit was commenced or continued without a substantial basis in law and fact. Because both requirements are met, the Times is entitled to summary judgment on its anti-SLAPP claim and an award of attorney's fees. Background. Relying on a legal document and contemporaneous communications, the Times publishes an article describing allegations of workplace misconduct by Wayfarer executives. On December 21st, 2024, the Times published a news article written and reported by Megan Twohey, Mike McIntyre, and Julie Tate entitled "We Can Bury Anyone Inside a Hollywood Smear Machine," and an accompanying video. The article and video reported on a sexual harassment and workplace retaliation complaint filed by actor Blake Lively with the California Civil Rights Department in connection with her work on the Wayfarer-produced film It Ends With Us. Ms. Lively filed her complaint against Justin Baldoni, who directed and starred in the film and co-founded Wayfarer, and Jamie Heath, Wayfarer's CEO and the film's lead producer. She alleged that Mr. Baldoni and Mr. Heath engaged in misconduct on the set of the film, and that Mr. Baldoni subsequently engaged a crisis PR specialist, Melissa Nathan, to tarnish her reputation. The article and video explicitly relied on and cited to Ms. Lively's CRD complaint. They also relied on and cited documents incorporated into the complaint, including text messages and email communications between Mr. Baldoni, his publicist Jennifer Abel, and Ms. Nathan. Wayfarer and its affiliates file a meritless defamation action against the Times in federal court. Dissatisfied with the article and video, Wayfarer, along with several affiliated people and entities, sued the Times. It first filed in California State Court, though the complaint was never served. Then, after Ms. Lively sued the Wayfarer plaintiffs in federal court, the Wayfarer plaintiffs countersued. The federal court consolidated those suits into a single action, and the Wayfarer plaintiffs filed an amended complaint, which added the Times as a defendant. The amended Wayfarer complaint asserted 4 causes of action against the Times, all tied to the publication of the article and the video. The first was a defamation claim concerning the content of the article and video. The second was a substantially similar false light claim. The third and fourth were claims for promissory fraud and breach of implied contract, both related to the Times communications to the Wayfarer plaintiffs seeking comment for the article and video, specifically an allegation that the Times had promised to delay publishing the story. The federal court dismisses the claims against the Times with prejudice. The Times promptly moved to dismiss the Wayfarer plaintiffs' claims against it with prejudice. The federal court granted that motion on June 9, 2025. The federal court's opinion made clear that the claims against the Times were meritless. First, it concluded that the defamation claim was mostly barred by New York's fair report privilege because the Times' story was based on Ms. Lively's formal complaint to the CRD, and that, even to the extent it may not be, the Wayfarer plaintiffs had failed to plead actual malice, a necessary element. Second, it dismissed the false light claim for the same reasons, and also because New York law does not recognize this cause of action. And finally, it dismissed the promissory fraud and breach of implied contract claims, concluding that no contract existed and that, in any event, the Times honored its promise by including the Wayfarer plaintiff's comment in the article. Because the federal court determined that these defects could not be fixed by amending the complaint, it dismissed all the claims against the Times with prejudice. To date, the Wayfarer plaintiffs have not appealed the federal court's decision. The Times files the instant case, that's this case, to recover its attorney's fees under New York's anti-SLAPP law. Following the federal court's dismissal of these claims, the Times brought the instant case to recover the attorney's fees it incurred in defending against the Wayfarer lawsuit. The Times filed its complaint with the dismissed Wayfarer complaint from the Southern District of New York and the federal court's opinion attached on September 30th, 2025, and served Wayfarer shortly thereafter. Wayfarer answered on December 2nd, 2025, after an agreed-upon extension. The Times now moves for summary judgment. Argument. Wayfarer's liability for the Times' fees is an open and shut issue under New York's anti-SLAPP law. The Wayfarer plaintiffs filed suit in federal court over a newspaper article and video that concern a matter of public interest. And they initiated and continued that lawsuit without a substantial basis in fact and law, as the federal court's opinion dismissing the claims against the Times with prejudice makes clear. In defending against that lawsuit and bringing this one, the Times incurred legal fees. It is therefore entitled to summary judgment on its anti-SLAPP claim and an award in the amount of those reasonable fees. The Times is entitled to mandatory attorney's fees under New York's anti-SLAPP law. New York's anti-SLAPP law provides that a defendant in an action involving public petition and participation may maintain an action, claim, cross-claim, or counterclaim to recover damages, including costs and attorney's fees, from any person who commenced or continued such action. And it specifies that costs and attorney's fees shall be recovered upon a demonstration that the action involving the public petition and participation was commenced or continued without a substantial basis in fact and law, and could not be supported by a substantial argument for the extension, modification, or reversal of existing law. So, to be entitled to a mandatory award of attorney's fees, the Times must show 1. That the Wayfarer lawsuit involved public petition and participation, and 2. That the Wayfarer lawsuit was commenced or continued without a substantial basis in fact and law, and could not be supported by a substantial argument for the extension, modification, or reversal of existing law. The record makes plain that the Times meets both requirements and that there are no material factual disputes about either. The Wayfarer lawsuit against the Times falls within the anti-SLAPP law because it involved public petition and participation. To come within the scope of the anti-SLAPP law, the Times must first show that the action, the federal Wayfarer lawsuit against it, involved public petition and participation. An action involving public petition and participation means a lawsuit without any communication in a place open to the public or a public forum in connection with an issue of public interest, or any other lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest, or in furtherance of the exercise of the constitutional right of petition. The term public interest shall be construed broadly and shall mean any subject other than a purely private matter. Okay. The article and video that were subject of the Wayfarer plaintiffs' claims against the Times were published on a news media website, which is a quintessential public forum. Wayfarer does not dispute this fact. And the article and video concerned allegations of workplace misconduct and retaliation by and against prominent members of the entertainment industry. Subject matter comfortably within the broadly construed bounds of the public interest. Okay. The Wayfarer plaintiffs commenced or continued the lawsuit without a substantial basis in fact and law. The Times also meets the other requirement imposed by the anti-SLAPP law, that the federal Wayfarer lawsuit against it was commenced or continued without a substantial basis in fact and law, and could not be supported by a substantial argument for the extension, modification, or reversal of existing law. Wayfarer does not contest, nor could it, that the federal court dismissed its claims against the Times with prejudice under the Federal Rule of Civil Procedure 12b-6. That undisputed fact alone is all that is needed under New York law. New York courts have held that when a lawsuit fails to state a claim, it necessarily lacks a substantial basis in law. Whether the motion to dismiss is granted under New York's CPLR 3211A7 or Rule 12b-6 in federal court, the result is the same because the distinction between the two standards is not salient here. To begin, the basis for dismissal of the defamation claim, the fair report privilege, and a lack of actual malice would be recognized in state court as in federal court. And dismissal here was not a close call. So weak was the Wayfarer case that the federal court declined to let the Wayfarer plaintiffs amend the defamation claim. Instead, it found that the request to amend with additional unspecified facts suggests a dilatory motive to extend the litigation rather than a legitimate belief that amendment will alter the court's determination. The federal court's opinion likewise makes clear that the other Wayfarer claims against the Times were exceptionally weak, and therefore lacking a substantial basis in fact and law for purposes of the anti-SLAPP statute. It called the promissory fraud and breach of implied contract claims meritless, explaining that the principal legal argument supporting them makes little sense. And it dismissed the false light claim because, among other reasons, New York law does not even recognize that cause of action. Put simply, all the claims were held by an experienced trial judge to be not just losing, but deeply and irreparably flawed. There can thus be no doubt that the suit against the Times was commenced or continued without a substantial basis in fact and law, and that is accordingly entitled to a mandatory award of attorney's fees. All right. The attorney's fees sought by the Times are reasonable. Because the Times is entitled to a mandatory award of fees, all that remains is to determine the amount. A fee award must be reasonable and not excessive. To determine what is reasonable, courts consider a variety of factors, including the time and labor required, the skill necessary to provide effective counsel, the result obtained, and the experience of the attorneys involved. The amount sought by the Times, which is almost certainly a fraction of what the Wayfarer plaintiffs, multiple lawyers from multiple firms, charge for work on the motion, is reasonable as a matter of law. The fees charged by the Times outside counsel were reasonable. The fees charged by the Times outside counsel for defending against the lawsuit were reasonable. As detailed in the McGraw affirmation, the Times responded to the Wayfarer suit as it would any other high-profile defamation action filed against it. It retained seasoned media lawyers who frequently handled defamation lawsuits. It ensured that those lawyers charged competitive rates. And it supervised those lawyers so that they completed work efficiently while still vigorously representing its interests. Those lawyers won in federal court, securing dismissal of all claims against the Times with prejudice. They charged a total of $153,074.70, which the Times paid. The Times is thus entitled to an award in that amount. The Times is also entitled to the reasonable fees incurred by its in-house lawyers litigating this case. So to explain that, in-house is the lawyers, they kind of, it's quite self-explanatory, but like Wayfarer have a legal department, which is where, you see names like Emaine Mezian and Joseph Lanius. They are the in-house counsel who work for Wayfarer as part of Wayfarer staff. The Times has that too, many corporations do. But so the outside counsel would be a private firm that they have hired, much like, Wayfarer have hired Friedman's firm. Friedman's firm is outside counsel, so is Fritz's. That's what they're referring to here. The Times is also entitled to fees incurred litigating the instant fees case. This is so even though the case has been handled by its in-house lawyers rather than outside counsel. As outlined in the McGraw affirmation, those fees were also reasonable. The Times' in-house lawyers worked efficiently to prepare a complaint and summons, and later this motion. And the proposed rates for each of those in-house lawyers are commensurate with the market value of their services, as other courts have recognized. So the Times is likewise entitled to payment of those fees in full. Conclusion. For the foregoing reasons, The Times respectfully requests that this court grant its motion for summary judgment under Civil Practice Law and Rules 3212. Award The Times its reasonable attorney's fees in the amount of $181,622.70 and provide such further relief as the court deems appropriate. Okay. So they have included some stuff like the article itself, a transcript of the video with Megan Toohey, some of the legal fees, the invoices, etc. I won't go through all that because, you know, it's just a lot to go through and it's not really kind of necessary. Now, my view of the fees compared to UK legal fees, it's a hell of a lot of money. We would not be, you know, for the work that was done, we probably would not be paying that kind of money in the UK, 180 odd thousand or 150,000 plus. But that is because I think we just have, our, legal fees are not quite as dramatic. So I wasn't, but given that it's New York, they are a good firm of attorneys. I'm not surprised. I certainly don't think it's, extortionate amount of money. Now, what else they also included a copy of the Trump v. Trump. So that's where Donald Trump sued his niece, Mary Trump, and a bunch of others, including the New York Times. For most of the defendants, the motion to dismiss was upheld. Was granted. And then what else is there? I'm just switching screens. Where is it? So this. Yeah. Okay, I got it. Sorry, I had to go through some of these. There's quite a few exhibits. So this is kind of like the Trump v. Trump decision, basically. And it's just the confirmation about the attorney's fees, legal expenses, and costs. And basically, they're just saying to the court, look, all of this stuff was, agreed in this case. We want you to follow it. So they cite this case quite a bit, actually, in their motion. And they were actually part of that case too. I'm going to be kind of really honest about this. And we haven't seen Wayfarer's response. So I am keeping a very open mind about that. Now, we all have an opinion on Judge Lyman's ruling in the motion to dismiss in the main case. And that's for all of them, that's Blake Lively, Brian Reynolds, Leslie Sloan, and the New York Times. And we can hold that opinion, but in this case here, this is a separate case, and you have to separate yourself from it, right? Because the judge who gets assigned to this is just going to look at the law, and he's going to say, okay, what is the law? Well, there's the two requirements, okay? So the underlying lawsuit must involve public petition and participation, which they have proven. And then the second requirement is that the law must have been commenced or continued without a substantial basis in fact or law. And the fact that it was dismissed with prejudice in its entirety is pretty strong. It is pretty strong that they have met that kind of, they've hit both of those elements. So let's kind of separate that out a little bit. The public petition and participation element, right? That's fairly airtight. The Wayfarer lawsuit which is the one that was dismissed. It's not the Blake Lively one, right? Again, those are also two separate cases, although they're all consolidated, right? It is not the same causes of action, and therefore not necessarily the same evidence, and so on and so forth, that is needed. Lively has her claim against Wayfarer, right? So we put that to one side. Wayfarer, we are focusing solely on the claim that Wayfarer brought against Lively, against Ryan Reynolds, against Leslie Sloan, and against, importantly, the New York Times, because that is what counts here, not the Lively case. So the Wayfarer lawsuit, it did target a Times news article, a Times video. It reported on sexual harassment and retaliation allegations. And it was based heavily on a formal complaint to a government agency, i.e. the California Civil Rights Department. So, New York courts, they repeatedly hold the view that news reporting is a public forum. Misconduct allegations involving public figures or major entertainment productions are matters of public interest. The definition of public interest is actually very broad. Wayfarer's own answer, which I did in my last video, admits the publication occurred. So there's no factual dispute there. And then we look at the requirement that the lawsuit was commenced without a substantial basis in fact or law. And again, separating my personal opinion, and I have many, which are not good for the, they're not the most flattering for the New York Times either. But again, looking just at the facts as they're going to come to this court, and the judge is not going to be interested remotely in the Lively case or much more than was it dismissed with prejudice or not, as far as the Wayfarer lawsuit goes. So my opinion is that they have kind of the requirements for no substantial basis in fact or law element is actually even stronger. Lyman, like it or not, dismissed every claim with prejudice. He stated that the claims were meritless. He found the legal theory behind the contract and fraud claims makes little sense. I'm quoting there. Those were his words, makes little sense. He held that the defamation claim was barred by the fair report privilege. He found that there was no actual malice. He said that about all of them actually. Ryan Reynolds, Leslie Sloan. The only person he did not ascribe a lack of actual malice to was Blake Lively. Lyman also rejected the option to dismiss without prejudice and allow Wayfarer to amend because he said it would be futile. And he suggested that the plaintiff's request to amend was dilatory. So there is quite a lot there. When we say dilatory, we're talking about, Wayfarer just seeking to prolong litigation where there is no base for that litigation. So New York courts have been quite clear on this. If a complaint is dismissed for failure to state a claim, it necessarily lacks substantial basis in law. And a dismissal with prejudice is even more conclusive. A claim that is not legally recognized in New York, right, false light, is automatically baseless. Now, I know that Wayfarer were wanting their claims to be decided on California law, but yes, they will. Their response will probably argue that, and that's the kind of thing that I'm anticipating in their response. I'm expecting them to say, actually, we're keeping our option open to appeal, because the New York Times actually made a point of saying, oh, well, they have not appealed. Well, we know that Wayfarer can't appeal right now. The So there's been a stop the clock applied to their appeal. And if you remember, I think it was back in October, November time, Judge Lyman issued an order where Wayfarer's ability to appeal would be stayed until he had ruled on Lively's motion for the Section 47.1 remedies. Right? And only once that ruling had come in and judgment had been made on her request for those remedies, would the clock start for Wayfarer to appeal the various things, including this. So that is what has happened there. So Wayfarer, I'm expecting them to say, well, at the moment, the option to appeal is actually not available for us, and they will probably issue a copy of that order. That's what I would be hoping to see, and to argue that actually we do intend to appeal, or we're keeping our options open. What else is there? I mean, claims that cannot be cured by an amendment, which is what Lyman effectively ruled in his order, are the textbook definition of without substantial basis. And that is exactly the kind of the scenario, I guess, that the anti-SLAPP statute was designed for. So again, I haven't seen Wayfarer's response, and I keep my mind very, very open. And I'm expecting it to be good. But if I was looking at this as it stands, I kind of have to be honest and say, look, do you know what? They've actually made a really strong case. And it is going to take something impressive from Wayfarer in their response to get me to kind of to move me away from my belief that I think the New York Times will win this, because that is where I am right now. And that's not got nothing whatsoever to do with Lively, her claims. Do I think Wayfarer sexually harassed anyone or retaliated? No, I do not. Now, I am the person who found the metadata, the October 31st metadata. I have been very, very strongly behind the idea and the notion that the New York Times colluded with Lively for months. I think some of the more recently unsealed Taylor Swift texts also suggest that, because you got those text messages around, is it the 5th of December? It doesn't it doesn't specifically say anything about the New York Times article, but you can see they're clearly like, oh, is everything ready to go? Oh, yeah, it's going to be delayed by a couple of weeks, but yeah, ready to go, blah, blah, blah. It very much alludes to the likelihood that they are talking about the New York Times article, and they're talking about it nearly 3 weeks before it was released. So there's that. Wayfarer may bring that in their argument as well. Say, oh, yeah, okay, you based it on all of this stuff. However, this was you were plotting this for ages. I just don't think that's going to be a strong argument, in all honesty, because, Lively to for the fair report privilege to have applied, Lively must have anticipated filing a lawsuit, and in the end she did. And that's what Lyman said as well. And I couldn't disagree with Lyman on that. That's what the law says. So I don't like it. I don't like it at all, but that is where we are now. The fee request is well supported and reasonable. They used experienced media counsel. The rates, I did have a look at the rates. They weren't extortionate by any stretch. Now, they look a lot to me because UK legal rates are quite a bit lower. They're still expensive, but they're not £1,000 an hour like even for some, some of the higher up people like partners in law firms, you're looking at about 3, 4, £500, maybe a bit further upwards, and barristers can be, a lot of money as well. But I mean, even a paralegal in the bills here was a few hundred, £300 an hour, $300 an hour. A paralegal in the UK, you're looking at about, I don't know, around £100 an hour, if that. So, yeah, it is a lot of money compared to, when I look at it compared to UK legal fees, it is a lot of money. But when I compare it to kind of the average for New York for the kind of this area of law, it seemed pretty average. They did win complete dismissal. They have provided detailed billing records, which we can have a look at in a minute. Actually, we'll look at now. I won't go through them, but I think these are the outside counsel bills. We'll just flick through quickly, but it's better down here. So it's like this, right? So Kim Bolger she's a partner. She's expensive. So she's billed for half an hour to review a court order. She's billed for half an hour to speak to another attorney about the judgment. You can see they're about $322, $322.50. She's charged for 20 minutes, $215 for an email. And that's one of the bills. There's a lot here. What is this? Yeah, this bill is for yeah, this bill is for just under $10,000, and so on and so forth. But you see, I mean, they write down what they're billing for, like, how many hours, etc., etc. So 0.3, that's 30 minutes. Is it 30 minutes? It would be 0.3 would be 30 minutes over here, but it looks like it is. Where did I see? I saw something interesting. So it's nearly $3,000 here for Kim Bolger email correspondence with Megan Toohey regarding motion to dismiss strategy, and to review Friedman deposition. So there's quite a lot there. And that total there was $62,000, nearly $63,000. So there's a lot of work done, and that's how these are billed, is for quite literally for everything. So Kim Bolger is a partner. Her rate, you got the rates here. Her hourly rate is $1,075 an hour. She spent in this invoice anyway, 26.10 hours, and she charged $28,057.50. Then we've got the associate. I don't know what the first name is, but the surname is Kate Gumpert. 45 hours. That's for an associate at an hourly rate of $750. So the amount there was $33,750. And then we got the paralegal, 1.90 hours at a rate of $490 an hour. Again, that's a lot of money for a paralegal compared to UK figures, but not compared to other US, especially specifically in New York. So that was for that was $931, and it just keeps going down. So they provided invoices for absolutely everything, which do download, which do detail exactly what they've done, for how long they've done it, who did it, how much did they bill for that person to do that. And we've got other professionals here. So you got partner counsel on this one. You know who the partner is. A. Levine was the counsel. Their hourly rate is $865 an hour. Other professionals, and that could be research assistants, legal assistants, secretaries, admin. It could be a bunch of people. It's not specific. It just says other professionals. Now they have different rates. So you got W. Adom. Their hourly rate is $165 an hour. But then you got this other person, then S. Griststein. Their hourly rate is $440 an hour. So like the Adom, the cheaper of those two, then conducted compliance, reviewed and formatted, also e-filed notice of appearance. So this is this is like an admin basically. They've checked compliances and they have filed very, kind of like the basic things, the notice of appearance and all like that. You don't need counsel to deal with, or partner, or even a paralegal really. So that's how you reduce the bill, by not having your higher fee earners to do kind of simple admin jobs. Okay, so now we've looked at the bill. So anything else I wanted to say about this? I mean, right, so we've been through the bill. Yes, so they requested a modest amount compared to typical defamation defense costs. Again, I think that's true. They also seek in-house counsel fees, which New York courts routinely award anyway. The motion cites multiple cases approving times in-house rates specifically. Again, Trump v. Trump is one of them. New York courts, they rarely second-guess fee requests when the client actually paid the bill, the hours are proportional, the case is high stakes, or, as was the case here, the result was total victory. So the issue I have for Wayfarer in their prospects in this case is there is no real viable defense. And again, before anyone starts jumping up and down going, but he didn't sexually assault her. Again, 100%, I've been on board with that since day one. So I don't need to be persuaded of that. But again, that is not what this case is going to answer or look in. They're not going to even remotely look into it, right? The judge in this case is not going to give a shit whether Lively was sexually harassed or not, whether Wayfarer win her case against her and defeat her claims or not. It's not going to matter. At the end of the day, this is about the New York Times reporting, using the First Amendment rights to report on a case that is of public interest. And, it used legal instruments to do so, i.e. the CRD. So is there defamation? I think it's going to be really hard for Wayfarer to argue that there was, but that again, that is not the case here. It's going to be, did Wayfarer have a meritorious claim against the New York Times? At any point, did their claim against the New York Times specifically, not Ryan Reynolds, not Leslie Sloan, this is just about the New York Times, did it have merit? And I'm struggling to see how they defeat the New York Times argument that it didn't. Because all the judge in this case is going to do is go look and say, well, what did Lyman say about it? Oh, he threw it out at the earliest opportunity with prejudice, specifically stated it lacked merit. There was a failure to state a claim, that some of the claims made no sense, etc., etc., etc. And when you put all that together, that is all this judge is going to want to know about. And for that reason alone, I think that Wayfarer could lose this. If they lose it, they lose it. Because again, this is not a win for Lively, ever. It just gives the New York Times their legal fees back. And I think they stand a good chance of getting that back because, they are a renowned publication. If Leslie Sloan, because she has filed an anti-SLAPP request for her fees, and I do not think she's going to get it because she's trying to say, well, I'm a publicist, so technically, I should be afforded the same rights. I work with newspapers. I don't think so. I don't think that's the case. I don't think it should apply to her. She's also, her motion for her fees are still sitting pending. But I'm less optimistic that she will win hers. I do think that the New York Times have got a strong case. But let's see what Wayfarer say first and foremost. I think that's the most important thing. So just to kind of confirm though, the response from Wayfarer is due on February the 27th. And then the New York Times get to a right reply, and that is due by March the 13th. So we will keep a lookout for that, and I will keep you updated. But I'm very much team Wayfarer. But where I think a filing is, its arguments are quite sound, regardless of what side that is. I will say that I've always said that I would do that. I'm not going to just, say, oh, this is complete and utter crap just because it's on the opposite side to the team I support. This is a strong motion, so we'll see how it goes. All right, guys. Well, thank you for listening. I keep forgetting to say this, but if you could like my video and subscribe if you don't already, it really would help my channel. Thanks, guys. Take care of yourself.